Before we go any further, you need to understand what Officer Dale Pruitt did not know when he snapped those handcuffs shut at 6:38 a.m. on a public beach in September of 2021. He did not know that the man sitting cross-legged in the sand, bare feet, eyes closed, hands resting open on his knees, had spent 31 years on the South Carolina Supreme Court, that he had authored over 200 written opinions, that he had been cited in federal rulings across 9 circuits, that 4 sitting United States senators had attended his retirement dinner in 2019, and that the keynote address was delivered by a former U.S. Attorney General. He did not know any of that. What Pruitt saw was a black man alone on a beach before sunrise, and in the narrow geography of his assumptions, that alone was enough. What followed over the next 18 minutes would generate a federal civil rights lawsuit, a $9.3 million settlement paid by Harrington County taxpayers, the termination of 1 police officer, the forced early retirement of 1 supervisor, and a federal consent decree requiring the complete overhaul of the Harrington Police Department's bias training protocols. Dale Pruitt's career is over. That's consequence. The city paid $9.3 million. That's accountability. This is the full story. His name is the Honorable Elias Croft. He is 71 years old. He served on the South Carolina Supreme Court from 1988 to 2019. He has 2 daughters, 4 grandchildren, and a house 200 yards from Pelican Cove Beach that he has owned since 1997. He goes to that beach every single morning. He was going to that beach the morning Dale Pruitt decided he didn't belong there. Before we continue, where are you watching from right now? Drop your city or country in the comments. We have viewers from all over the world joining us on these stories, and we love knowing where justice matters to people. Welcome, wherever you are. Pelican Cove Beach sits at the southeastern edge of Harrington, South Carolina, a mid-sized coastal municipality of approximately 42,000 residents, positioned 50 miles south of Myrtle Beach along what locals call the Quiet Coast. Harrington is a city of 2 distinct geographies, and anyone who has spent more than a weekend there will tell you so. The western half of the city, anchored around the commercial corridor of Route 17 business, is predominantly white, predominantly affluent, and predominantly the beneficiary of the tax base generated by the county's coastal tourism industry. The eastern half, where Judge Croft has lived for 24 years, is predominantly black, predominantly working to professional class, and has historically received a fraction of the municipal services that the western districts take for granted. Pelican Cove itself sits in what city planners call a transitional zone, a polite way of saying it is a public amenity that both sides of the city technically share, but that white residents of the newer Harbor Point development have increasingly treated as a semi-private extension of their HOA. The beach stretches for approximately 3/4 of a mile. At its northern end, it terminates at a small wooden pier maintained by the Parks Department. At its southern end, it dissolves into a protected wetland preserve. The sand is pale and fine. In the summer months, it is crowded by 10 a.m. Before 6 a.m., it belongs to the herons, the pelicans, and the handful of residents who understand what the beach is like before the world wakes up. Judge Elias Croft was one of those residents. On September 14, 2021, the temperature at sunrise was 66 degrees. The humidity was low. The sky was moving through its colors, black to indigo to a thin band of orange at the waterline, when Croft settled onto the folded towel he always brought and assumed the position he had held every morning since his wife Margaret passed away in 2010. Sitting, still, eyes closed. Dale Pruitt's patrol car rolled to a stop in the Pelican Cove parking lot at 6:14 a.m. Elias Croft was born on March 3, 1950 in Columbia, South Carolina, the second of 4 children born to Reverend Thomas Croft and Edna Mae Croft, née Williams. His father ran a congregation of 340 families at First AME Church of Columbia for 38 years. His mother taught 4th grade at Washington Elementary School until her retirement in 1989. Theirs was a household built on 2 currencies, discipline and language. You said what you meant what you said, and you were always, always prepared. Elias Croft learned to be prepared early. He graduated valedictorian of his class from C.A. Johnson High School in 1968, the year Martin Luther King was assassinated, the year the Civil Rights Act of 1968 was signed, the year America announced loudly that it could hold contradictions without resolution. Croft enrolled at Howard University that fall on an academic scholarship and graduated in 1972 with a degree in political science and a minor in philosophy. His senior thesis, titled The Architecture of Constraint: How Law Codifies Social Hierarchy, earned the department's highest distinction and was later excerpted in a political theory journal out of Yale. From Howard, he went directly to the University of South Carolina School of Law, where he graduated third in his class in 1975 and was immediately recruited by the Civil Rights Division of the NAACP Legal Defense Fund. He spent 8 years there, litigating housing discrimination, employment discrimination, and voting rights cases across the Southeast. He argued before federal appellate courts on 14 occasions. He won 11 of those arguments. In 1983, Governor Richard Riley appointed him to the South Carolina Circuit Court. He was 43 years old and the youngest judge appointed to that bench in 20 years. In 1988, Governor Carroll Campbell, a Republican, elevated him to the South Carolina Supreme Court, citing his extraordinary judicial temperament and intellectual rigor. It was a bipartisan acknowledgement in an era when those still existed. He served 31 years on that court. During that time, he authored 217 written opinions. He presided over landmark decisions on prison reform, voter rights, environmental protection, and juvenile justice. His 2004 majority opinion in State v. Hargrove established precedent that was cited by the U.S. Supreme Court in 2009. He received the South Carolina Bar Association's Judicial Excellence Award in 2007, 2013, and 2017, the only judge to receive it 3 times. He retired on June 1, 2019, to a standing ovation in the South Carolina Supreme Court chamber. His retirement dinner at the Columbia Convention Center drew 400 guests. Senator Tim Scott and Senator Lindsey Graham both attended. Former U.S. Attorney General Eric Holder delivered the keynote address. After retirement, Croft returned to Harrington, where he had owned property since 1997 and where he and his late wife Margaret had planned to spend their later years together. Margaret died of ovarian cancer in March of 2010. The beach became his chapel. He went every morning, 6 a.m., sometimes earlier, sometimes later, depending on the light, and he sat in the same spot 50 yards from the water line, and he breathed. On the morning of September 14, 2021, he had risen at 5:30. He made coffee, dark roast, no sugar, the way Margaret always made it. He put on a gray long-sleeve shirt, navy linen pants, and sandals. He drove the 6 minutes to the Pelican Cove parking lot. He parked in his usual spot. He walked to his usual place in the sand. He settled his towel. He closed his eyes. He was not causing a disturbance. He was not creating a scene. He was not doing anything wrong. He was a 71-year-old man watching the sun come up over the ocean, the same way he had been doing for 11 years. That was the entirety of his crime in the eyes of Dale Pruitt. Dale Wayne Pruitt was 34 years old on the morning he arrested Elias Croft. He had been a patrol officer with the Harrington Police Department for 7 years. Hired in August of 2014 following a brief stint as a security guard at the Harbor Point Marina, a private facility serving the upscale residential development that bordered Pelican Cove Beach on its northern end. Pruitt's personnel file, which was obtained through a public records request filed by the plaintiff's legal team in January of 2022, revealed a document that reads less like a service record and more like a warning that nobody acted on. By September of 2021, Dale Pruitt had accumulated 11 formal complaints in 7 years of service. 11. That is not a rounding error. 11 formal complaints in 7 years. That's not bad luck. That's a pattern. Of those 11 complaints, 8 involved allegations of racially biased enforcement. 3 involved allegations of excessive force during misdemeanor arrests. 2 had been escalated to the department's Office of Professional Standards for investigation. Both investigations were closed, one marked unsubstantiated, one marked inconclusive, within 60 days of being opened, without interviewing a single civilian witness beyond the initial complainant. The incidents themselves painted a consistent picture. In November 2016, Pruitt stopped a black male driver on Coastal Highway 9 for what he documented as a failure to signal lane change. The driver, a 46-year-old high school principal named Marcus Webb, was detained for 22 minutes, had his vehicle searched without consent, and was issued no citation. Webb filed a formal complaint the following day. The complaint was reviewed and closed within 30 days. No disciplinary action was taken. In March of 2018, Pruitt responded to a noise complaint at a residential address on Easton Street, a predominantly black neighborhood in Harrington's Eastern District. Responding officers documented a gathering of approximately 12 people in a private backyard. Pruitt's incident report noted that the gathering appeared suspicious given the hour. It was 9:15 p.m. on a Friday. No citations were issued. No arrests were made. 3 residents present that evening filed complaints about Pruitt's conduct, citing aggressive questioning, demands for identification without legal basis, and what one witness described as a hands-on-hips, get-off-my-beat posture that several attendees found physically intimidating. 3 complaints from one incident. All 3 closed. No action taken. In January of 2020, a 62-year-old black woman named Dolores Simmons was ticketed by Pruitt for loitering on a public sidewalk outside a pharmacy on Merchant Row while waiting for her prescription. The charge was dismissed by a municipal court judge within 2 weeks. The judge's written dismissal noted, in language notable for its restraint, that the statutory definition of loitering does not extend to a citizen standing on a public sidewalk during business hours. Simmons filed a complaint. It was reviewed and closed within 45 days. No action taken. His supervising sergeant at the time of the Croft incident was a 17-year department veteran named Sergeant Gary Hollenbeck, a man who, according to 3 separate officer depositions taken during the civil litigation, had been informally made aware of concerns about Pruitt's conduct by at least 2 fellow officers as early as 2019. Hollenbeck took no formal action. He would later testify that he had counseled Pruitt on professional demeanor on 2 occasions, but could produce no documentation of either conversation. This is where institutional tolerance becomes institutional complicity. You do not accumulate 11 complaints by accident, and you do not keep your badge through 11 complaints unless the system around you has decided in some quiet and deliberate way that the complaints do not matter. They mattered on September 14, 2021. They mattered when Elias Croft did not stand up fast enough to satisfy Dale Pruitt's authority. Do you think officers with 8+ complaints for racial bias should face mandatory review and suspension? Drop your answer below. Pruitt had been assigned the Pelican Cove and Harbor Point sector for the morning shift, a rotation that had been standard practice since the Harbor Point HOA began formally lobbying the City Council in 2019 for enhanced patrol presence along the coastal corridor. The HOA's petition had specifically cited concerns about unauthorized individuals utilizing beach access during off-peak hours. The city had complied with the request without a formal vote. At 6:14 a.m., Pruitt pulled into the Pelican Cove parking lot. His dash cam, which was active as required by department policy, captured the lot at that moment as holding 3 vehicles: Croft's 2018 dark blue Volvo, a white Ford pickup registered to a fishing equipment company, and a rusted Honda Civic belonging to a 23-year-old white woman named Kaylee Marsh, who was jogging the shoreline at that hour as she did every Tuesday and Thursday morning. Pruitt walked to the beach. Kaylee Marsh was running. The officer watched her for several seconds, then turned his gaze south along the waterline. Elias Croft was 50 yards away, seated in the sand, facing the ocean. Pruitt walked toward him. What happened next was captured by 2 separate recording devices: Pruitt's body camera, which activated automatically when he unholstered his radio, and Croft's own cellular phone, which he had placed face up in the sand beside his folded towel, and which began recording, as it did every morning, set on a timer to capture sunrise, at 6:00 a.m. on the dot. That second recording would become the cornerstone of the federal civil rights lawsuit. Pruitt stopped approximately 4 feet from Croft. He stood over the seated man and said, "Hey, you, on the ground, get up." Croft opened his eyes. He looked at the officer above him. He did not immediately stand. He said, "Officer, good morning. I am meditating. I am not doing anything wrong." Pruitt's response took 4 seconds. The body camera recorded them. "I said get up. Now. ID. Give me your ID." Croft rose, slowly, deliberately, with the careful movement of a 71-year-old man who has spent 30 minutes seated in sand. He brushed his linen pants. He straightened his back. He said, "Officer, I have every right to be on this public beach. I am not required to identify myself unless you have reasonable suspicion of a crime." Do you have reasonable suspicion of a crime? This is where bias becomes accusation. This is where assumption becomes confrontation. Because Dale Pruitt had no reasonable suspicion of a crime. He had a feeling. He had a posture. He had a man who was the wrong color in a space that someone had quietly decided was the wrong space for him. Pruitt said, "The crime is you being out here at this hour making people uncomfortable. You understand me?" Croft paused. He looked at the officer for a long moment. Then, very carefully, "I understand you perfectly." The words were measured. They were precise. They were the words of a man who had spent 31 years listening to attorneys and choosing language with surgical care. They were not defiant. They were not aggressive. They were simply accurate. Pruitt did not receive them that way. That right there, that attitude, that's what's going to get you in handcuffs this morning. At this point, Kaylee Marsh, who had looped back on her jogging route, was approximately 60 feet away and slowing. She would later provide a written witness statement to federal investigators. She described Croft as completely calm, soft-spoken, not threatening in any way. She described Pruitt as aggressive, close, leaning in. Croft said, "Do what you need to do, officer, but I want you to know that I am recording this interaction and I intend to provide this recording to your department's professional standards office. Then you should have led with that. I led with my name. You didn't ask for it." Pruitt stepped closer. His body camera shows his hand moving to Croft's left forearm. "Sir, you are being detained for questioning pursuant to a suspicious circumstances report. You are required to comply." "What suspicious circumstances report? Filed by whom? At what time?" There was no report. There had been no call. There was only Dale Pruitt standing on a public beach at 6:19 a.m., fabricating a procedural justification in real time. Croft would later testify that he recognized this immediately. He had spent 31 years reviewing police conduct. He knew the language of justification being constructed around him like scaffolding around a building that didn't exist. He did not resist. He did not raise his voice. He stood, hands at his sides, and said, "Officer, I want to be very clear. I am not resisting. I am not fleeing. I am complying with your instruction. I am also a retired Associate Justice of the South Carolina Supreme Court, and I am asking you, formally and for the record, whether you have a legal basis for this detention." The body camera captured what followed. A pause. Then, "Put your hands behind your back." This is where assumptions become handcuffs. At 6:38 a.m., Elias Wendell Croft, retired Associate Justice of the South Carolina Supreme Court, 31 years of service, 217 written opinions, recipient of 3 Judicial Excellence Awards, was placed in handcuffs on a public beach in the county he had served for 3 decades. Kaylee Marsh stopped jogging. She was now fully recording on her own phone. She later said in her federal deposition, I remember thinking, this man is the most dignified person I've ever seen in handcuffs. He just stood there, like he knew something the officer didn't. He did. Do you think this arrest would have happened if the victim had been white? Drop your honest answer in the comments. At 6:41 a.m., 3 minutes after the handcuffs were applied, Sergeant Gary Hollenbeck arrived at Pelican Cove Beach in his department-issued Ford Explorer. He had been monitoring radio traffic and responded to what Pruitt had logged as a suspicious person, uncooperative, Pelican Cove Beach access. Hollenbeck was 17 years with the department. He had supervised Pruitt since 2018. He would later claim, under oath in federal court, that he had arrived at the scene without foreknowledge of the detainee's identity. The sequence of what followed is documented frame by frame on 3 separate recordings. Hollenbeck walked toward Pruitt and the handcuffed Croft. He said, "What have we got, Dale?" Pruitt said, "Suspicious individual, refused to identify, uncooperative." Croft, hands behind his back, said calmly, "Sergeant, my name is Elias Croft. I am a retired Associate Justice of the South Carolina Supreme Court. I live at 2219 Shoreline Drive, 200 yards from where we are standing. I have been coming to this beach at this hour for 11 years. I have done nothing wrong. I am asking that these restraints be removed immediately." Hollenbeck looked at him. Then he looked at Pruitt. Then he looked back at Croft and said, "Can you verify that?" Croft said, "My wallet is in my left front pocket. My South Carolina judicial identification card is in the first slot. You are welcome to retrieve it." Hollenbeck retrieved the wallet. He opened it. He looked at the card for several seconds. According to witness Kaylee Marsh's deposition, his expression changed visibly. He said very quietly, "Dale, take the cuffs off." Pruitt said, "Sarge, he was uncooper." Hollenbeck said, "Take the cuffs off." The handcuffs were removed at 6:47 a.m. Elias Croft had been in restraints for 9 minutes. 9 minutes. Hollenbeck asked Croft if he required medical attention. Croft said no. Hollenbeck apologized, briefly, using the word regrettable once. Croft did not respond to the apology. He picked up his folded towel. He picked up his phone. He walked back to his car. He drove home. He sat in his kitchen. He called his daughter, a federal public defender named Annalise Croft Warren, practicing out of Columbia, South Carolina. He told her what had happened. She told him she would be there by noon. The federal civil rights lawsuit was filed 63 days later. Do you think the supervisor who arrived and said only regrettable should have faced consequences too? Tell us below. Kaylee Marsh's phone video hit the internet at approximately 11:30 a.m. on September 14, 2021, less than 5 hours after the handcuffs came off. She had posted it to her personal social media accounts with a caption that read, "I watched this happen this morning at Pelican Cove. This man was meditating. He did nothing wrong. I don't know who he is, but someone should." By 2:00 p.m., someone did. A retired Columbia attorney recognized Croft's face in the video and posted his name and judicial biography in a reply that was shared approximately 14,000 times within the next 2 hours. By 6:00 p.m., the video had been viewed more than 800,000 times across platforms. By midnight, the count exceeded 4 million. National media coverage began on the morning of September 15th. The headline that circulated most widely, from a Washington Post piece published at 8:12 a.m., read, "Retired SC Supreme Court Justice handcuffed while meditating on beach." The Associated Press followed within the hour. By noon on September 15th, the story had been covered by every major television network and had generated over 240,000 comments across social media platforms. The Harrington Police Department issued its first public statement at 3:45 p.m. on September 15th. The statement used the word "unfortunate" 4 times, the phrase "we take these matters seriously" twice, and the phrase "pending internal review" once. It did not include an apology. It did not name Officer Pruitt. It did not acknowledge that a former state Supreme Court justice had been placed in handcuffs without legal cause on a public beach. The statement was, by any measure, catastrophically insufficient. The city received over 3,000 written complaints in the 72 hours following the incident. The mayor's office reported that its email server experienced a service interruption due to volume on September 16th. Dale Pruitt was placed on paid administrative leave on September 16th, 2 days after the arrest. He was terminated on November 3, 2021, 49 days after the incident. The termination letter, a portion of which was obtained through public records and entered into the federal court records, stated in its concluding paragraph, "Officer Pruitt's conduct on September 14, 2021 demonstrated a fundamental failure to exercise lawful judgment, a demonstrated pattern of racially disparate enforcement documented across multiple prior incidents, and a willingness to fabricate procedural justification for a detention that lacked any legal basis. His continued employment within the Harrington Police Department is not compatible with the constitutional obligations of this office." Sergeant Hollenbeck retired voluntarily, according to the department, on January 14, 2022, 4 months after the incident. The federal civil rights lawsuit filed November 15, 2021 by the firm of Croft Warren and Associates on behalf of Elias Croft alleged violations under 42 U.S.C. Senator 1983, 4th Amendment unlawful seizure, 14th Amendment equal protection, and deliberate institutional indifference. The case was settled on August 22, 2022, 11 months after the arrest. Harrington County agreed to a settlement of $9.3 million. The settlement included $7.1 million in compensatory damages to Croft, $1.4 million in attorney's fees, and $8,000 designated for the implementation of a 5-year federal consent decree requiring the complete restructuring of the HPD's bias training, complaint review, and early intervention programs. No amount of money returns 9 minutes, but $9.3 million sends a message. On March 7, 2022, Elias Croft appeared before the Harrington City Council's Special Commission on Police Accountability, a body convened in the aftermath of the incident at the direction of the City Council and the Office of the County Administrator. He was the final witness called. He spoke for 18 minutes without notes. He began by thanking the Commission for their time. He acknowledged the difficulty of institutional reform. He said, and the transcript captures this word for word, "I want to be direct with you about something. I am not here because I want your sympathy. I am here because I have spent 31 years watching this system from the inside. I know what it can do when it functions correctly. and I know what it becomes when the people responsible for its integrity decide that accountability is inconvenient. He described the morning of September 14th in clinical measured language, the kind of language he had used for 3 decades in written judicial opinion. He described the moment the handcuffs were applied as a clarifying experience. He said, "I have written opinions about unlawful detention. I have reviewed evidence in cases involving racially biased policing. I have sat above it analytically for years. And then I was on the beach where I have gone every morning for 11 years, and a man put his hands on my wrists, and I understood, in a way I had not understood before, what it means to have your freedom removed by someone who believes your presence is the problem." He paused for several seconds. Then he said, "I was not afraid. I want to be clear about that. I was not afraid. I was something worse than afraid. I was unsurprised." The room was silent. He continued, "That is the thing I want this commission to sit with. Not that it happened to a retired judge, but that it happened in a way that felt entirely consistent with what I have watched happen to black men in this country for my entire life. The badge does not discriminate between a retired Supreme Court justice and a 22-year-old who had nothing in his pocket but his phone. The assumption is the same. The only thing that changes is the consequence for the officer." He concluded his testimony by addressing the commission directly. "You have an opportunity here. Not to repair what happened to me, that cannot be repaired, but to make a decision about what kind of department this city is willing to fund, defend, and put on the streets of a neighborhood where people are trying to live. I hope you make the right one. History will record which choice you made." The commission voted unanimously 4 days later to adopt all 14 of the consent decree's proposed reforms. After hearing his testimony, do you believe these reforms would have happened without the viral video and the 9.3M lawsuit? Tell us honestly below. Here is what the Harrington case gives us that most of these stories do not. It gives us documentation, not just of the arrest, though we have that on 3 separate recordings, not just of the settlement, though the $9.3 million is a matter of public record. It gives us a paper trail that runs 11 complaints deep across 7 years, through 2 closed internal investigations, past multiple supervising officers who chose not to act, all the way to a moment on a public beach where a man sat in the sand at sunrise and was told, in effect, that his presence required justification. 11 complaints in 7 years. That's not bad luck. That's a pattern. And patterns do not maintain themselves. Patterns are maintained by systems, by review processes that close without findings, by supervisors who counsel without documentation, by institutions that have quietly decided that the complaints of certain people carry less weight than the convenience of certain officers. That is the real story here, not Dale Pruitt. Dale Pruitt is a conclusion, not a cause. He is the visible end of a process that began the first time a complaint was filed and nothing happened, and the second time, and the third. By the 8th complaint alleging racial bias, the Harrington Police Department had a body of evidence sufficient to conduct a meaningful performance review, implement a remediation plan, or separate the officer from the force. They did none of those things. And so on the morning of September 14, 2021, Dale Pruitt drove to Pelican Cove Beach with 11 complaints behind him and a badge in front of him, and he made the kind of decision that people make when they have been told, repeatedly, by the silence of their institution, that their decisions are fine. The real question is, what changes now? The consent decree in Harrington requires body camera activation protocols, complaint review timelines, early intervention triggers at 5 complaints within 3 years, mandatory de-escalation certification, and independent civilian oversight of the Professional Standards Office. These are not radical proposals. They are baseline accountability measures that dozens of departments across the country have implemented in the wake of federal review. They should not have required a $9.3 million lawsuit and a retired Supreme Court justice in handcuffs to prompt their adoption. Because if we don't fix the system that allowed 11 complaints to accumulate without consequence, we're just waiting for the next Dale Pruitt and the next Elias Croft. Except the next Elias Croft may not have a daughter who is a federal public defender, may not have spent 31 years navigating the legal architecture of accountability from the inside, may not have a phone that was recording. The system should not require perfect victims. It should simply require accountability. Dale Pruitt's career is over. That's consequence. The city paid $9.3 million. That's accountability. Elias Croft still goes to the beach every morning. That's resilience. The The question is whether Harrington and the dozens of cities watching this case from a distance will build systems that make the accountability automatic rather than requiring a viral video, a federal lawsuit, and 11 years of ignored warnings to arrive at it. That question has not yet been answered, but the record is being kept. If this story moved you, if it made you angry or sad or determined, share it. The more people understand how these patterns work, the harder they become to ignore. Subscribe for more full-length accountability stories every week. Final question. Do you believe police departments should face mandatory federal review after 5 or more substantiated bias complaints in a single year? Drop your answer below. We read every single one.